Welcome to the channel. Welcome to EDSTAR. Today we are going to uh, analyze those the topics which has been discussed in the House of Parliament and in this session, in this monsoon session. So we will only discuss those topics which are quite relevant for UPSC examination. So as per the first question, the question which is asked by the to the Minister of External Affairs, that will the Minister of External Affairs to be pleased to state that whether government is aware of Indian who relinquish their Indian citizenship is increasing since 2019. So basically, this question is related to the renouncement of Indian citizenship. So in this question, our important context will be about citizenship. What is citizenship? How the citizenship is provided, and as the question is asked basis of the on the basis of the renouncement, so we will put a light on what is how to terminate the how the Indian citizen is renounced or terminated. So let's dive into this. So this is the answer which has been given by the Minister of External Affairs. So the overview, first we will look onto the overview that MEA has given a data that yes, MEA has given a data that till 2019, 1,44,000 has renounced as gave up their Indian citizenship, then 85,000 in 2020, and so on. Every data has been given in the parliament that how many people have Indians have gave up their Indian citizenship till 2019 to 2024. In total, in total, the figure is 10 lakhs 36,860. The total renouncements that has happened from 2019 to 2024. So basically, what do you mean by renouncing the citizen? Renunciation refers to voluntarily giving up Indian citizenship, often to acquire citizenship of another country. Whenever a person he uh, acquires citizenship of another nation, so he oblique she has to give up the Indian citizenship because we don't have the dual citizenship concept in our country, and which act actually provides the provisions of the citizenship, that is Citizenship Act 1955. This is the act which actually in which also India does not permit dual citizenship. So what are the let's look into the constitutional provisions. Constitutional provisions related to citizenship. So the first provision, that Article 5. What Article 5 says? It defines citizenship. It's defined citizenship. So from Article 6 to Article 8, what does it say? It addresses the citizenship of those persons migrating from Pakistan. Migration from Pakistan or returning from abroad during partition, And what does the Article 10 says? It ensures continuity of citizenship rights subject to laws. And what about Article 11? It empowers Parliament. This article empowers Parliament to make laws on citizenship. So, as what you have seen that we have Citizenship Act 1955. So, how does this act came into the how does this act came into this? So, this is just because of the Article 11, because Article 11 empowers the Parliament to make laws on the basis of the citizenship. So that leads us to the Citizenship Act 1955. So, and defines what are the in this act, the Citizenship Act 1955. It defines the modes also. What are the modes? Modes are by birth, by descent, by registration, and by naturalization, by incorporation of territory. Whatever the territory India incorporate in its nation, so those people they are going to be the part of Indian national. This is, for example, Sikkim, integration of Sikkim in 1975. So, as we have seen that people have renounced their citizenship, what are the basic reasons for a renunciation? First reason will be economic opportunity. Second reason will be, I mean, family reunification, that those members who have been living in the abroad, so people just the family members join them and settle in the abroad. Second reason can be family reunification. No dual citizenship and better opportunities, and other than immigration policies also, because liberal policy, because in the developed nations there are some liberal policies related to the immigration. So what are the trends? I mean, we can just see that that as per the trends that there is a spike in 2022 to 24. It reflects global mobility post covid. We can see the global mobility. I mean, as per the data, 30% of India's IT workforce, they are leaving India. So it also impacts some other sectors like agriculture sector and the space sector. Okay. So what are the basic opportunities? I mean that India can leverage its diaspora through OCI cards, granting visa-free travel, economic rights. and Lee. So let's get to the next question, which is by the Ministry of Law and Justice. So this question is basically it is on whether government has conducted any recent studies or consultations to evaluate the effectiveness of free legal services. It is basically on the free legal aid services under the Disha scheme. So as we will look into the scheme, that what is Disha. So what is Disha? Disha is designing innovative solutions for holistic access to justice. So this is the Disha scheme. So what does it provide? It is to provide accessible, affordable, and citizen-centric legal services. Okay, what it will provide? It will provide accessible, affordable, citizen-centric legal services. So this is the main aim and objective of the Disha. So, as the Department of Justice has also answered this question, that designing innovative innovations for holistic access to just Justice India. So, which aims to fulfill constitutional mandate. What is the constitutional mandate? Article 39A, which is providing free legal aid to ensure equal access to justice. Article 14, guaranteeing equality before the law, and Article 21, which is protecting the right to life and personal liberty, which also includes access to justice. These are the constitutional mandate. Okay, so the DISA scheme is approved for the period of 2021 to 2026. So as per the answer given by the ministry, that by 2030, by June 30, 2025, by June 30, 2025, uh, that Disha has reached 2.110 crores beneficiaries across the India. This number of people of India have used this Disha scheme to ensure legal services. So, what are the key legal? The key components of Disha. The key components are tele law, Nyay Bandhu, which is pro bono legal services, and legal literacy and legal awareness programs. Tele law, Nyay Bandhu, and legal literacy and legal awareness programs. So, what does the tele law do? What is the what is the tele law? Tele law, it actually connects citizens to lawyers for for pre-litigation advice. For example, just resolving disputes before they reach courts, using technology and all. And for this tele law, that the number has been given. This is the toll free number 14454. This is the toll free number for the citizens through which they can connect themselves to the lawyer for pre litigation advice. So, what is the impact? The impact is that it helps citizens resolve issues like property disputes. I mean, what are the pre-litigation advice for the? I mean, for the property disputes, then domestic violence or the labor rights, and it will also reduce courts burden. So next is the Nyay Bandhu. What is Nyay Bandhu? What is Nyay Bandhu? Uh, this is pro bono legal services, and the purpose is uh, provide a free legal aid to the. I mean, how it is different from the tele law. I mean, the tele law is also providing it is just connecting citizens to lawyer. And the pro bono legal services, that Nyay Bandhu, it will provide legal aid services, but to who those eligible beneficiaries. I mean, for this eligibility is required. And what is the eligibility? That the beneficiaries should be under the section 12 of Legal Services Authority Act 1987. It will only be provided to those beneficiaries only in this Nyay Bandhu, like women, children, SC, ST, economically weaker sections. So in this Nyay Bandhu, I mean, there is a mobile app which is also named in itself, that Nyay Bandhu mobile app. It connects to pro bono advocates, I mean the volunteer lawyers with registered beneficiaries needing legal representation. Okay, so here the beneficiaries will get connected to the volunteer lawyers. So what is the impact? Actually, the impact will it empowers marginalized groups who cannot afford legal fees, aligning with Article 39A. So coming up to the last key component, which is about legal literacy and awareness program. It sensitizes citizens about their rights, duties, mm, rights, duties, entitlements under the constitution and laws. It will make people learn. It is conducted through regional implementing agencies. It is conducted through, I mean, regional implementing agencies, just like Sikkim State Women Commission, Arunachal State Legal Services. Okay, so just for example, there is 56 legal awareness programs, 56 legal awareness programs that has been running in 6 languages. This is aired on DD India. So, what is the impact? It educates citizens, especially in rural and remote areas. So, as we have seen that total till June 30, 2.10 crores beneficiaries have added to the Disha. So, this is a very huge achievement, as it has been initiated in 2021. So, uh, as we have seen that it is a very, stark uh, initiative by government of India. So we can just look into the challenges as well. What are the challenges? Challenges is that awareness gap. A lot of people are not aware about this scheme. Despite 2.10 crore beneficiaries, many remain aware of rights. As we can see that in the, those areas, just like from the northeast and J&K, the number is not very good. Shortage of lawyer. In this program, we need pro bono lawyers, like those volunteers lawyers. So we can just see shortage of lawyers in this. And one more important thing is that funding, because post 2026 funding and integration of these legal state bodies need, they need robust fundings to avoid disruptions. Funding to avoid disruptions. I mean, for example, as those lawyers who are going to work for the people who are not going to pay. The government and the judiciary need to pay them, so the funding is required. So that's why, because that is a lack of funding leads to the shortage of lawyers. So Disha is a transformative step towards holistic justice, aligning with the preamble's vision as well. The word justice is in the preamble. So, however, addressing digital divides, lawyer shortages, and regional disparities is critical for sustained impact, especially in vulnerable areas like Northeast and Jammu Kashmir. And scaling up with secure funding and awareness can make Disha a global benchmark. So, next we are coming up to the last question, which is actually, those last question of the relevant one. It is to the amendments to the preamble. As we have seen in our, in the daily news and the social media, that we are just hearing that the word socialism and secularism, it are going to be, going to be removed from this, from the preamble of the constitution. So the Ministry of Law and Justice is asked about this, that whether it's going to be removed or not, or we are just moving ahead with these words. And I mean, what is the relevance and socialism and the secularism, and as well as that this atmosphere is created by some social organizations. So let's dive into this. Preamble of Indian Constitution describes India as a uh, sovereign, socialist, secular, democratic republic. Okay. So the words, those words, socialist and secular, they were added through 42nd Amendment Act, 42nd Constitutional Amendment Act. In 1976, during the emergency under Indira Gandhi government. These terms reflect India's commitment to welfare, welfare state. Though that socialism and equal treatment of all religion, equal treatment for all religion, that is secularism. So, as the query, I mean, as the query that has been asked, that is it, I mean, any plan to remove? So, government of India, I mean, the Ministry of Law and Justice, it is clearly mentioned that there has been no formal decision or proposal has been announced by the government of India. No formal decision. Says Government of India has not initiated any legal or constitutional process to remove socialism or secularism from the preamble. Public or political decisions may exist, but no official proposal has been announced. In November 2024, in November 2024, the Supreme Court, in the case of Dr. Balram Singh and others versus Union of India, dismissed petitions challenging 1976 amendment. The court clarified socialism in India means welfare state promoting social and economic equality. It is not a barrier to growth of private sector growth. And secularism, and about the secularism, it is a part of basic structure, as it is part of basic structure of constitution, ensuring equal respect for all religions. Parliament has the power to, and the third point, that Parliament has the power to amend preamble, but changes must align with the constitutions. So I will just write it down. Parliament has the power to amend preamble, but it must be aligned. Those changes must align with the constitution's core principles. So, as we have seen, though, that in this part, the one question it has been asked, that office bearers of some social organizations. So let us just see that what is a social organization. What is the role? I mean, those organizations' role. Some social or political groups may be advocating for considering these words, creating public discourse. I mean, but they might do this. They might be, I mean, they might be involved in for considering these words to create a public discourse. However, this does not reflect the government's official actions or stance. So, as we have seen that the government stands that there is no current plan to remove socialism or secularism from the preamble. So, let's dive in to what is preamble. So, what is let's dive into it. What is preamble? It is introductory statement to the Constitution of India, to Constitution of India, as sovereign, socialist, secular, democratic republic, and to secure all its citizens. Okay, these are the keywords what I have mentioned right now. So it has been adopted. When it was adopted, it was adopted on 26 November 26 November 1949, and it was effective. When it was effective on 26 January 1950. It outlines the objectives, philosophy, and guidelines. What does it outlines? Pardon me for my writing because I'm not till now I have not been acquainted with this writing book. So just pardon me. Uh, what preamble outlines? Preamble outlines objectives, philosophy, and guiding principles of the Constitution, serving as its soul and identity. So, what is the purpose? What is the purpose of preamble? Acts as acts as guiding light for interpreting constitution provisions, reflects aspirations of India's diverse population. It defines the core values and national goals. So, what are the key components? As we have just seen that those words, though, then just put a light on the what are the key components. Key components is the source of authority. We the people of India. We the people of India. This is the source of authority. Nature of Indian state. Nature of Indian state. And what is the nature? Sovereign, socialist, secular, democratic. These are the nature of Indian state. What is the objective? Justice, liberty, equality, fraternity. So these are the objectives. And if we will see the historical context, that in the historical context, you will find that preamble was drafted by the Constitutional Assembly, which was chaired by Dr. B.R. Ambedkar, and this actually the foundation of the preamble. I mean that this foundation of the preamble was laid by Jawaharlal Nehru by giving objective resolution. So this is very important for you. Objective resolution, which was moved by Jawaharlal Nehru, and it laid the foundation of preamble. So till date, the amendments in the preamble, if we are going to see, then the 42nd constitutional amendment. What does the constitutional amendment 42nd it do? It did. It was done in 1976. It added socialist, secular, integrity. And what is the legal status of amendment? Preamble can be amended under Article 368, but changes must not violate the basic structure of the Constitution, as per given in the Keshwanand Bharti in 1973, and also in 2014, Supreme Court in Dr. Balram Singh versus Union of India reaffirmed that socialism and secularism are the part of the basic structure. So, government's decision to maintain the preamble's status quo is pragmatic, preserving constitutional integrity and social harmony. Our ongoing debates highlight the need for public education and inclusive governance to counter polarization and misinformation. But for us, it is not important because the government of India has no formal decision has been taken by them right now. So that's all for today. We will come soon again with the next house session and those important topics. Thank you.